Mr. Fish, I have a few questions that I've been asked to raise with you by call participants and their legal representatives. The first concerns the payments that were made to the estates of those who had died. First of all, is this correct, that the fund was, the payment was made to the estates of the deceased rather than to any specific type of relative?
Lump sums were to the estates, but the bereavement payment was specifically to a cohabiting partner.
To what kind of inquiries would the Skipton Fund make before making a payment where there was someone who was claiming to act on behalf of an estate?
So we'd ask for a copy of probate, I believe, a copy of the death certificate, and any other evidence to confirm they were the executor.
In terms of bereavement payments, were parents excluded from bereavement payments?
Yes, I think so. I think it was just cohabiting partners, yeah.
Do you know why that was the case?
No, that was Department of Health policy.
I asked you this morning about the steps taken by the Skipton Fund to advertise its existence. And you made reference to making contact with the Macfarlane Trust to ask the Macfarlane Trust to pass on information to its beneficiaries. Did you or anyone else at the Skipton Fund, to your knowledge, ever consider writing to UKHCDO and asking them to inform all those on their database about the Skipton Fund and the scheme?
I'm sure that it may have happened in the early days of the fund. I don't recall us ever writing to them specifically, but that might have been something that the Department of Health did when the scheme was set up. So I believe you probably have meetings with them. They'll be able to confirm.
FibroScans, we discussed this afternoon the reliance placed on FibroScan results in determining whether an applicant qualified for stage 2 payments. What consideration was given to the accuracy or lack of accuracy of FibroScan results?
We never relied solely on FibroScan, so yeah, we would always get as much information as was available, make an informed decision based, taking into account everything. So yeah, on occasion there would be reasons why a reliable FibroScan couldn't be taken, in which case we would then rely more heavily on whatever evidence was available.
And did those reasons why a FibroScan result might not be reliable include particular medical conditions that an applicant might suffer from, as far as you can recall?
Can't recall. All I remember was an instance where it kept hitting a rib, so we were they could only get a reading of the density of the rib. I'm not entirely sure why that was the case. But no, I don't think there were specific medical conditions that prevented it from being useful. Well, there may be. I'm not an expert.
But that's not something you recall considering?
No.
During the winding down of Skipton and the transfer over to the NHS Business Services Authority, were you aware of registrants having problems being recognised by the Scottish Infected Blood Support Scheme and being registered with the English Infected Blood Support Scheme instead?
I think there were a couple where it wasn't clear which country the infection occurred in. So yeah, I do vaguely remember there was maybe one or two cases where it wasn't clear which country it was. I can't remember how that was resolved, whose decision it was, which scheme they were appointed to. But yeah, I don't think in every single case it was clear cut.
You told us about what reasons there might have been for concluding that an applicant was not eligible for a stage 1 payment. You've told us also about the policy or practice towards deceased haemophiliacs considered to have been at 100% risk or close to of HCV infection. I'm not asking you about any individual case here, but can you think of any reason why a claim from the estate of a severe haemophiliac who had received treatment with NHS blood products and had died before 2003 would have been refused?
Only if there was evidence of naturally clearing the virus, but that would have been unlikely to have existed either way. But that could have been a reason why, if there was evidence still available which did suggest that they'd not had a chronic infection.
But you can't think of any other reason why that kind of category of case might not succeed?
No, if we knew that they'd received clotting factor, then we knew they were definitely exposed to hepatitis C. So it then just comes down to chronicity.
And leaving aside the question of chronicity or natural clearance, is it correct to say that the Skipton Fund's approach, based on its understanding of the Department of Health's requirements, was that where there was evidence of an individual with a bleeding disorder having received a concentrate at any time prior to September 1991, that was deemed to be the cause of their hepatitis C infection with no need for further inquiries?
Yeah.
You made, I think, some reference that before seeking, in your evidence earlier, that before seeking medical input on medical questions, you might carry out your own research. What kind of research would you undertake?
Just to see if I could find any literature, medical literature online that might help. Obviously, we would only consider recognised studies. It wouldn't just be Wikipedia, for instance, but just to see if we could find any of our own information that's already widely available in the public domain.
Would you ever rely upon the products of your own research as a basis for refusing an application?
Not without discussing it with a medical director or specialist.
In cases where intravenous drug use was a possible cause of infection based upon information or records provided by the medical practitioner, is it correct to say that the applicant would not see the application before it got to you, because as we discussed it came straight from the doctor, and so the applicant would have had no opportunity to dispute the accuracy of the intravenous drug use entry?
Yeah, I think typically they came direct from the doctor. I mean, the doctor probably would have shown them or given them a copy if they'd asked before it was sent, but I think generally speaking most came direct from the doctor.
If you received evidence of an entry in medical records which suggested intravenous drug use, would you, before taking a decision on the application, go back to the applicant and ask if that entry was accepted as correct?
No, I think we did take what the doctor said as the facts.
If that was then disputed by the applicant, so an entry in the medical records asserting intravenous drug use was disputed by the applicant as being wrong as a matter of fact, either at the application stage or on appeal, what approach was taken to that? How would that be resolved?
So we would certainly have asked the doctor why it was mentioned on the form, what was the basis for their assertion or them mentioning it, to try and find out why it was written by the doctor.
Would you, at that stage, invite the applicant to set out their account? Or was that something that would only become an option at the appeal stage?
Yeah, so as you mentioned before, the form doesn't have an area where the applicant can give their personal statement. So, but then if they'd written back to dispute what the doctor had said, they presumably would have explained why they thought that was inaccurate. So the fact that we then went back to the doctor would have been because of having received further information from the applicant.
If you had an applicant saying, what's the reference to intravenous drug use in my medical records is just wrong as a matter of fact, I've never taken intravenous drugs, and a doctor saying, well, I don't know, but all I'm doing is providing you with the medical records which contain a reference to intravenous drug use, how would you resolve an application in those circumstances?
Can't recall. It'd be an unusual thing to be written if there was no basis. Like, I don't think a doctor would write that lightly in their medical records, but yeah, it would be a difficult situation where it's the doctor's word or the record's word against the applicant.
Do you recall ever deciding an application on those facts? I think we've seen evidence to suggest that there might have been such a case, but I appreciate you may not recall individual cases.
Yeah, I can't remember that specifically happening, but yeah, in the summaries you provided, I think 3 of the appeals about intravenous drug use was the reason we rejected it, were overturned because they denied intravenous drug use. So yeah, if we had scope to consider personal statements, that may have helped.
Did you ever come across a situation in relation to medical records where a doctor was able to say there was previously a transfusion record, and therefore I can confirm that I've seen a medical record vouching transfusion, but by the time the application to the Skipton Fund was made, that record had been destroyed or lost?
I can't recall a specific case of that, but it sounds like something that we could take into account. If the doctor was adamant they'd seen it and for whatever reason it was no longer available, then yeah, that would hold weight, obviously.
You told us in relation to stage 2 decisions that you relied on the opinion of the doctor completing the stage 2 application form a lot, or quite a lot. And that their opinion could form the basis for a successful stage 2 application. Why was a different approach taken then to stage 1, when you would look behind what the clinician was saying?
With stage 2, it's always an option for further test results and tests to be done, or wait for more routine bloods to be done. So there was always that option of building up a better picture of the evidence.
Sorry, my fault. I don't think I put the question sufficiently clearly. At both stage 1 and stage 2, you would have a form completed by a clinician, and presumably a local clinician or a clinician who had some direct knowledge of the applicant. Would that be right as a matter of generality?
Yeah.
In relation to stage 2 decisions, as I understand your evidence earlier, the primary basis for allowing an application for stage 2 would be what the doctor told you in the application form. Not always, but as a matter of generality.
Yeah, but we would also have all of the test results available, whereas with the stage 1 applications, it would have presumably been based on cases where there were no medical records that we could see ourselves. So with stage 2, we actually can see what they're basing their decision on, whereas with stage 1, that wasn't always possible.
So it comes back to this key question of there being available medical records to demonstrate either at stage 1 the transfusion, or at stage 2 the state of liver disease. Is that right?
Yes. Yeah.
Was it impossible for an application to the Skipton Fund to be made by an applicant acting without a supporting medical professional?
Yeah, I think we did insist it had to be a medical professional who completed their form.
Just going back to the evidence you gave about Elizabeth Boyd and her informally seeking advice on cases from the Royal Free, or from clinicians at the Royal Free Hospital. I think you've mentioned your understanding that advice may have come from liver specialists, and you gave us, I think, Professor Deshako's name as one of those. Other than Professor Deshako, did you ever know the name of the individual clinicians who Miss Boyd was consulting?
At the time, quite probably, but I can't recall which, because she was involved in the haemophilia department, so the people she knew best would have been haematologists, but she also had access to the hepatology department, so at the time I probably did know which doctors, but I can't recall their names now.
Were there ever occasions, as far as you can recall, where the medical advice received through this indirect route from the Royal Free Hospital was later contradicted by the opinion of the medical member or members of the appeal panel.
Can't recall that. No.
When I asked you about the issue relating to the DWP and fraud investigations, you talked about benefits authorities being told to disregard payments from named funds. As a matter of fact, did payments from the Skipton Fund appear on bank statements as emanating from the Skipton Fund, to the best of your recollection?
I think so, yeah.
Were concerns ever raised with you about issues relating to confidentiality or stigma? Because, as you've said, if you Googled Skipton Fund, it would come up with hepatitis C.
Not with the Skipton Fund, but I think it may have been raised by McFarlane Trust Benefits Beneficiary. And I think later their payments would have shown as MFET, which I'm not sure if you Google that would necessarily disclose.
The inquiry certainly had evidence that hepatitis C carried its own stigma, not least because of other possible routes of transmission associated with drug use and the like. Was that an issue that was ever considered by the board of directors in the context of how payments were made and what they might reveal? No,
so in the 2 or so years before I became the administrator, I don't think it was something that was raised, and neither after I started. So I'm sure if a beneficiary or an applicant had have raised that issue, we would have explored it, but I don't remember it being an issue with Skipton Fund.
You've acknowledged, Mr. Fish, in your evidence that at the initial application stage, you and whichever director was concerned was not routinely considering the potential totality of available evidence because you looked at the form and the records rather than personal statements and the like. And you've told us that was your understanding is that's what the Department of Health required or expected of you. Are you able to assist us with understanding where we might see that kind of instruction or guidance from the Department of Health? Because I don't think the agency agreement itself casts any further light on that.
No, I mean, the Department of Health should be able to assist with that. But one thing to note is that the English Infected Blood Support Scheme has almost the exact same application form as we had. There's no area on there where people can give personal statements. So obviously, following the major reforms, transferring it to the NHS BSA, it's essentially still being run in the same way as we did it. So that is almost a clear statement of their intentions to continue it as it was.
I think we've seen from some of the documents we've looked at and your evidence that the Department of Health had an involvement in either approving or signing off application forms and guidance notes for the Skipton Fund. Is that right?
Yeah, if we were changing forms or content of the website, we would quite often run it by the Department of Health to make sure they were happy with the way we'd worded it, to make sure it reflected how they saw the changes. For instance, the 2011 changes, we gave them a chance just to check that the wording, that they were happy with it on the forms and literature.
My apologies if I've already asked this question, Mr. Fish, and you've already answered it. But did you ever raise with the Department of Health, or to your knowledge, did any of the directors ever raise with the Department of Health this particular issue of the application process not allowing you to consider all potential available evidence, and that only being something that could be looked at the appeal stage?
It may have been something that was discussed when we presented the appeals panel statistics. They may have asked what they thought or what we thought was causing circa 50%. So I'm sure we would have given that as the reasons why.
And did the department ever say to you, well, there's no need for you to take that approach? You can redesign the application process to allow everything to be considered at the first stage?
No, if they'd done that, we would have been happy to do that.
Was it ever a concern that this was a policy rather than operational issue, or did that issue never cross your mind?
Yeah, I felt it was always something. Well, this was the way that the Department of Health wanted the scheme to operate, and they certainly never gave any indication that they wanted us to start taking personal statements or photographs of scars.
Those are the questions, sir, I have from core participants that I'm proposing to ask Mr. Fish. Do you have any questions?
Yes, just really on one general topic, which is the relationship of the Department of Health and Skipton. And can I start by asking you this very broad question? Essentially, the task of Skipton, as I understand it, was to decide who qualified for the scheme, if somebody qualified for the scheme against the qualifications which the Department of Health had set out. Is that
Yes.
right?
Yes.
So your job was to evaluate whether someone qualified, essentially.
Yes. Yeah.
And the person who did that, first up at Skipton for many years, was you.
Not first up, but yes, from 2006 onwards.
Yes.
It was initially Mr.
I said
Foster.
for many years it was you.
Yeah.
Now, the how to make that decision, that was a matter really for you, wasn't it? Apart from knowing that it had to be applying the standard of the balance of probabilities, and it had to begin with an application form.
Yes, and as we've mentioned, there was no area on the form that the Department of Health helped design where personal statements were sought.
Yes. Now, the difference between what is operational and what is government policy is drawn by the agency agreement. How to evaluate a claim, would you not say that was operational?
Yes, although I mentioned about the EBS application process, they've been operating for 2 years now, and they still don't have an area where people can give personal statements or submit photographs.
That may be, but I just want to concentrate on Skipton and what is truly operational and what is truly government policy. I think you've answered it. You said how to decide that someone was or wasn't on balance of probabilities qualifying within the scheme, whether for stage 1 or stage 2, was a matter essentially for Skipton. That's what they were there to do.
Yeah.
And no doubt, from time to time, you'd want to make sure that the department you were an agent for was reasonably happy with how you were doing things, or you might refer how you did things to them. That's as I've understood it. Am I right?
Yeah, but it was always my impression that we weren't to consider anything other than the medical information that was made available to us.
I see. That wasn't written down anywhere?
Maybe, but I started months after the scheme began, and then I was trained on how to consider applications. So it may have been something that was written down somewhere, but I've not seen it.
So you never said to anyone, to the chief executive, for instance, or the new chief executive when she took over, I think I need help to evaluate this. I want to do it this way. Can I do that? Because evaluation is part of the operational side of the affairs. You've just agreed.
Yeah, I think I've been there so long, and it had never been questioned by the Department of Health.
So basically, you went on doing what you'd always done.
Essentially.
Yes.
Although, yeah, once we did have the medical directors on board, we were able to look more closely at records where it didn't explicitly mention the use of blood or blood products, but we could weigh up the probability that such products would have been necessary.
Now, the other aspect which I want to ask you about in respect to the relations between Skipton and the Department of Health in the question of what's operational and what's policy, arises out of what you were saying this morning when you said that the government would come, the Department of Health would have a number of meetings, particularly more meetings than the regular annual review, if they were thinking of making changes to the scheme. And you said they'd come and discuss the options.
Yeah, they obviously didn't tell us everything that they were considering. For instance, when they increased stage 2 from 25 to 50,000, we knew that was under consideration, but we didn't know that they'd be introducing regular payments. So that's something that hadn't been mentioned to us. And they added a new qualifying condition to stage 2, B-cell non-Hodgkin's lymphoma. Until the day of the announcement, we hadn't heard that that was under consideration either. So the meetings were more to get a sense of the number of different types of applicants.
Well, you used the expression that they would discuss the options with you, with Skipton. The word discussion suggests that there's a to and fro of ideas. Was that the way it was?
No, that was a bad choice of words. So they would tell us what was under consideration.
So it wasn't a discussion, it was telling you?
Yeah.
I see. Well, that answers that part of the question. Because if there had been a discussion, then it would be impossible to say that Skipton had no influence at all on what the Department of Health was doing.
Yeah, no, I accept that was the wrong word.
And when you were discussing how you did things, the operational side of the evaluation part of the job, essentially what Skipton were up to, did you discuss that, or did the Department of Health tell you how to do it?
When changes were made to the scheme, was that?
Well, throughout, at any stage.
Yeah. No, I just accepted they knew how we were considering applications. They were part of the initial design of the form, and it was never sort of questioned since then.
Yes, so you really assumed that because you'd been doing it that way and they hadn't objected, that it was okay to go on doing it that way?
Yeah, so they were happy with the way it was being administered. And like I mentioned, the current schemes do it, as I gather, in the same way. They certainly did for the year that I was there. So
well,
the department.
You say happy with the way they were doing it. I think you probably mean not unhappy. They never expressed unhappiness
Yes.
with it. Yeah.
Yes.
Well, that's all that I have to ask. Thank you very much.
Just one question, Mr. Fish, further question from me. We talked about the changes to the Skipton procedures that were implemented following the fraud by Mr. Foster, and I asked you about the counter-fraud, the NHS counter-fraud service. Skipton obviously wasn't itself an NHS body, although it was administering funds that came within the budget of the Department of Health. Who was it who either requested or required the involvement of the NHS counter-fraud service?
That was the Department of Health who sent them in to review the Skipton Fund in totality.
There's reference in the minutes of the meeting that we looked at, which was the meeting between you and members of the counter-fraud scheme, that there was going to be further discussions. They don't seem to have contemplated the further discussions involved you directly with the Department of Health about the proposed change procedures. Did you ever have any discussions with the Department of Health about the changes to the procedural requirements that were implemented in light of Mr. Foster's fraud?
I think after their review, they sent us a document of what they believe should be done, and we pushed back on a couple of the things because they would have been impractical. I can't now recall exactly which things we pushed back on, but at that stage, we gave our feedback on the recommendations that they wanted us to implement.
So you did
Yeah,
feel
just
able
accept them all.
you did feel able to raise some concerns about how applications should be considered.
At that stage, yeah, after that review.
Thank you. So unless there's anything further you have, Mr. Fish, is there anything that you would like to add?
No, I think we've covered a lot of what I used to do at the Skipton Fund.
Sir?
Well, I imagine that when you came as temp in November 2004 to work for Skipton, you never imagined that 15 years later you would still be working, basically doing the same job, albeit now for EIBSS. And that was going to be the next 15 years of your life, becoming the
Certainly
administrator.
not.
But it's been a great advantage to us that you were in that position, because we've been able to hear from the one person who was at the hub, at least, of the initial evaluation of both the stage 1 and stage 2 payments. And you've described how you inherited the scheme and how you operated that, and have been, as far as I can see, entirely open about the way in which you yourself went about those things, and the relations you had, and how you operated the discretion such as you saw yourself as having. So I'd just like to thank you for that, and for giving us a day of your time in order to do so, and obviously drafting your statements beforehand, all of which I have read with considerable interest. So thank you very much.
Well, thank you. No, it's a pleasure. Happy to help.
So tomorrow we have the evidence of Professor Howard Thomas.
Yes, 10 o'clock.
Yes.
So 10 o'clock tomorrow. Thank you very much.